Hello, Juan. How are you? All righty. How's everybody doing this morning? Everyone, I put the slides in the chat. If you want to download them, you can grab them.
Protect your home and your future. Call us at 833-LEAF-FILTER or visit getleaffilter.com.
mamita, me haces un favor, mamita.
All right, we're going to start in about 6 minutes. I hope everybody is having a good week so far. Today being Wednesday and all the middle of the week. All right, we're going to get started in about 2 minutes. Everybody see my screen where it says FAR contracts?
Yes.
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 All right.
Yes, we see it. I see it.
The technology works. It's always a good thing. All right,
Yes.
10 o'clock. We got 170 people have signed up for this, and we'll give it one more minute. People are still checking in. Just give me about few minutes. Also, the slides are in the chat. If you get into the chat, you can download the slides. You can follow along, keep them as a reference. Okay. All right. Okay, it's 10:01. We're going to get started. We're going to go over the FAR contract today. Start off, introduce myself a little bit. My name is Sam Saad. I'm an attorney here in Southwest Florida. Practice throughout the state, but my offices are in Naples, main offices in Naples, and then we've got offices in the Cape, Bonita, and Marco. So FAR contracts are the as is, of course, is the most used contract in the state. We're going to talk about the regular contract inspections, but of course the FAR as is and the FAR standard contract, all the other provisions are basically the same. So this presentation is going to be applicable to all the FAR contracts. And we're going to talk about the addendums. So because I'm a lawyer, we're going to start off with the disclaimer. I am an attorney and I'm going to be giving you some advice and some information, but it's not legal advice and you can't sue me if I'm wrong, but I'm not. All right, so let's dive right into the contract. So I'm looking at the residential contract for sale and purchase, the FAR contract, and we're going to talk through the contract in terms of through the contract terms, and I will be giving you pointers. I'm going to be talking about how to fill it out and then some negotiating and some strategic tips as we progress through it. So we're going to start right off, page 1, line 1 of the contract, the parties. You see on my slide here, I put right there at the top, make sure you have the right seller. So it's very important when you're doing your contracts that you have the right seller. And that seems like, oh, that should be obvious. But we get a lot of contracts with LLCs or trusts or probates, deceased folks, and the buyer puts the name that's from the property appraiser's website on the contract without doing further investigation as to who has the actual power to sell. And then we run into a problem when we do the title and the buyer finds out they don't have a valid contract. So make sure you have the right seller. I do a whole presentation on LLCs, trusts, probates, and other ways of dealing with title issues from when you're taking a listing. So I won't get into it in great detail here, but it's very important with an LLC, with a trust, with a probate, with multiple people, that all the parties who are required to sign the contract actually sign it to make sure it's binding. Otherwise, you could be going through the process and then somebody says, well, I never signed that contract, or the LLC never had the authority to sell all of the property in the LLC, therefore the contract isn't valid and we're not going to sell it to your buyer. And of course, in a seller's market where prices are rising, that's very quite possible for a seller trying to get out of the contract so they can better deal their buyers. So make sure you have the right seller. Make sure you correctly identify the property. You have to identify the property by address, property identification, and the short legal from the appraiser's office. This is line 7, 8, and 9 of the contract. Still right there at the very top. Now, Florida law basically requires 3 things to have a valid contract. You have to have your parties, you have to have your price, and you have to have your property. Everything else, the law will infer from a reasonableness standpoint. But you've got to have the right property. So make sure that you get vacant land, can be a major issue. Make sure that you get the right legal description, especially if there's no address associated with the property yet. That can be an issue. You've got lots in the estates, for example, the Golden Gate Estates that are not addressed yet. And then note that the personal property that transfers. So light fixtures, you cannot take the chandelier. In this contract, in your FAR forms, the washer and dryer are not included. So if you are taking buyers out and you're looking around and they ask you if the washer and dryer are included, make sure you know which form you're going to use, because this is a difference from the neighbor contract where the washer and dryer are included there. And note that the personal property transfers at no value. Line 22, the personal property is included in the purchase price, has no contributory value, and shall be left for the buyer. Why is that? Lenders don't make loans on personal property. They make loans on real property, real estate. So you've got to be very cautious there. If you're going to do personal property transfers and you have a loan, then we need a separate personal property sale agreement and bill of sale. And just contact me separately and I'll provide that. I have a form that you can use. It's very simple to fill out, as 3 blanks. Very easy to take care of that. When personal property is going to transfer for value and there's a loan involved. Okay. So the purchase price, obviously very important. One of the 3 required things to have a valid contract. This is the amount on line 27 that is used to calculate Ferpta. People get confused about whether they're calculating Ferpta off the net realized or the gross, which is the purchase price. It's off the purchase price. So let me talk for a minute about initial deposits too, while we're in this section of the contract, section 2 of your contract. If you are taking out buyers, you're spending a lot of time with your buyers. You're showing them houses, you're doing research, you're getting them what they want. If they're putting $1,000 down on a $500,000 purchase, they're not serious. Try to get your deposits up to keep your buyers honest. And of course, if you've got the listing, same thing. Why waste your time on a small deposit when your remedy under the contract is the deposit should the buyer breach? So if you keep your buyers honest, I would try to get your deposits up to between 5 and 10% whenever possible. Just to point out that you have to put the name and address of the escrow agent on the contract. That's on lines 32 to 34. And you got to do that by rule in the state of Florida.
Yeah.
So don't leave that blank. All right. Oh, I forgot to mention, if you have questions, you can feel free to unmute yourself and ask your question or type it into the chat. I see we have our first question from Terry. So don't go by county records on the owner information. How do you know if that is correct or not if you're the listing agent? So going back to that real fast, you got to talk to your listing agent. You got to check the records. You got to look for deaths. If there's LLCs or trusts involved, you're going to have to go to your listing agent and say, who has the power to bind this entity? So the short answer, Terry, is yes, talk to your listing agent. Okay. So one more point here on the purchase price, section 2 of the contract. Financing on line 38 is your loan amount. This is so important that you put this in there. There's a case that we're going to talk about in the course of this presentation where the buyer applied for a loan that was not, the buyer was approved for a loan that was not stated in the contract, and when they went to terminate because of the appraisal, the judge said, no, you never got the correct loan, so you never had a conditional loan approval. So make sure that your financing on line 38 is the correct amount. If you're going to apply for a different amount, please, please, please do a contract amendment. It's very important. We're going to talk about this further when we talk about the case in the financing section. So fill in your finance amount there on line 38. Okay. So in the FAR contracts, different from the NABOR contracts, time for acceptance of offer and counteroffer.
Listen to this.
You've got to have a signed and delivered contract. You cannot sit on a signed offer because the effective date in this contract is the date the last party signed or initialed and delivered the contract. So when
Did
you
hear that?
I'm sorry, does anyone have a question?
Okay.
The effective date is the date signed and delivered, not just signed. So if you date it, it's 10 o'clock at night, your offer comes over, seller accepts, seller signs, but then doesn't deliver until the next day because it was late at night. The next day is the actual effective date. And this is a difference from the NABOR contract. Okay, Kim, please review the best way to notify a seller that buyer has approval. Approval date is 25th. At this moment is conditional on a few minor. All right, Kim, we're going to get into the finance contingency and approvals in a little bit. So yes, I'll answer your question. Allie, regarding escrow, many buyers want to leave initial deposit of 1,000 until after inspection and leave a higher deposit. Is it still favorable if it adds up to 5%? Yes, that's fine if you want to put 1,000 down and then put more money down after the inspections. Just make sure that they realize that in the regular contract, I mean, I understand in the as is, if you want to terminate before you put your second deposit down, but the second deposit is not conditioned on completing and accepting inspections. So Allie, be careful there. If your buyer thinks they're going to get the inspections taken care of prior to putting a second down, then we got to modify the standard terms of the contract. So be careful about that. Okay. So we talked about delivery, make sure it's delivered. The closing date, unless otherwise modified, closing by the title clearance period or the CFPB rules, then the closing is on the closing date stated in the contract, and it is at the time during the day established by the closing agent. Now I laugh about that. I'm obviously a closing agent. I do a lot of real estate closings, but it's at the time established by the closing agent in the contract. However, it is at the time established by the bank because they are in any finance transaction, they are the ones that will tell you when you have funding authorization. Okay, questions. If offered, Marina is asking, if offered after 5 p.m., what would be the effective date? The next day? No, Marina, the contract goes until 11:59 unless it's after a holiday or a weekend, then it's 5 p.m. on the next business day. But that is not, there's a specific exception in the contract for the effective date. So if you deliver on a Saturday, Saturday is the effective date. So be careful about that. And then Dan asked, is a fax considered delivered? Yes, if you fax it to back to the buyer, you have a delivery. Ali is saying there appears to cause confusion that the date written for acceptance is when a response is requested, not negotiated, and accepted or defective. Ali, I don't understand what you're saying. If you want to unmute yourself, we can bring that up real quick.
Hi. Yeah, I was just saying that when you write the acceptance date on the contract in the beginning, it seems like that's when people want to try and get the response to you, not when you're going back and forth to try and have the effective date.
Well, when you remember, the effective date is the last date signed and initialed and delivered. So if you're going back and forth in a negotiation, even though you've written in an effective or an offer date, you can go past that offer date and still have an accepted and effective contract if you're in negotiations and everybody initials and signs off on the new date.
Okay.
Okay.
Thank you.
Then Kim and Renee, you're asking, is the effective date day 0 or day 1? It's day 1. So if you sign on Friday and it's delivered on Friday, then the first day for counting for the 15 days typical for inspections is the next day, Saturday. So and that counts. You don't skip to Monday because it's not the end of the period, it's the beginning of the period. Okay, so everybody got the dates down?
Yeah.
Any questions? Okay. All right. So talking about the closing date and the extensions, there are a few things that extend the closing date, but the closing date is otherwise a hard date in the contract that must be met by everybody. That's the title clearance period, the CFPB period. So you may get 10 more days under CFPB, and the force majeure may extend closing if closing services are unavailable. And we're going to talk more about force majeure, of course, when we get to COVID. Okay. So occupancy and possession. Unless leased, the seller must deliver occupancy and possession at closing. That means that you remove all your personal items and you deliver access. Now, let me talk to you a little bit about closing and possession and occupancy at closing. The contract says that you'll deliver possession and occupancy at closing. It does not say deliver possession and occupancy when the seller gets their money. So for all of you listing agents whose sellers say, don't you dare deliver those keys till I get my wire or my check, that is not what the contract says. And if it's Friday, it's 5 o'clock and we closed Friday at 5 o'clock and everybody is, all the banks are closed, the seller can come get a check from my office, or they can wait and get a wire on Monday. But we are closed, and the seller shall deliver occupancy and possession at closing. So be very careful there when you're coaching your sellers about when they have to release the keys and everything, because that can be a bone of contention, and you don't want to be stuck in the middle giving bad advice. Okay, so one note about pre-occupancy as well. Risk of loss transfers at the delivery of possession. So if you do a pre-closing occupancy, which I never recommend, then the risk of loss transfers at possession and not at closing. So it backs it up, and the buyer would be responsible once they take possession. Jim is saying closed even if not funded. Jim, I would never close a transaction that was not funded, so that's not a problem in my office. If you're dealing with title companies or closing agents that are declaring the property closed when they don't have all the funds, then that's a problem. You need to talk to them about their practices. Just as a practice point, as an attorney, you would never close a transaction unless I had all the funds in house and ready to close, and I was just waiting on bank approval. Okay. All right, leases. There's a section in here on leases. You check the box on line 70. And you must disclose in writing to the buyer and give them copies of the leases. The buyer then has 5 days to evaluate the leases and may terminate if they don't like what they say. Okay. Next up, let's talk about assignability. So this question comes up a lot. Buyer enters into a contract and they want to assign to a trust. They want to assign to an LLC. They want to add spouse to title, things like that. So the contract gives 3 choices. The buyer may assign and be completely released. The buyer may assign but not be released from liability, or the buyer may not assign. Now I'll tell you the Florida default would be to be assigned but not released. So if you don't check one of those boxes, that's going to be the one that goes. And then of course the seller cannot assign or be released because they are the ones that have title to the property. So the seller never gets out of the contract by assignment. All right, questions on the first part of the contract before I get into financing? Anyone? Nobody? Okay. So financing, of course, a huge part of our practice as realtors, brokers, closing agents. We got to talk in a little bit of detail here about the financing contingency. We'll go through it. This starts on line 83 of the contract on page 2. So obviously you can do cash. The buyer can bring all the cash to closing. It has to be by a wire, not by check. And certainly don't bring me a duffel bag full of dollar bills when you want to do your closing, although I've had that asked many times. So finance contingency, you need to check all the boxes and fill in the blanks. There's no defaults listed, so you could have a situation where you didn't have a valid contract because all the paperwork wasn't provided. Chloe, yes, we're recording and I'll post it to my YouTube channel afterwards so you can catch the beginning. Okay, so you have to pay attention to the deadlines. The financing is a hard date. It is 30 days after the effective date is the loan approval period on lines 89 and 90 of the contract. If you miss as the buyer and don't terminate prior to the end of the contract loan approval period deadline, then the buyer is going to be locked in. The buyer must use diligent efforts to obtain the loan. That includes providing all the paperwork and paying all the fees to the lender. And then the seller and the seller's agent are authorized to know what's going on with the loan approval. So the seller can call the loan officer and say, hey, per contract, I have a right to know what's going on here. Please tell me what the status of the loan is. Now, they can't reveal financial information like the credit score or anything like that, but they certainly can tell the seller, yeah, the loan is progressing and everything is fine in the approval process. So if the buyer gets approved, this is a major difference from FARBAR. I see a few of my favorite realtors here who use the NABOR contract. This is a major difference from NABOR. The buyer must deliver loan approval notice to the seller once they're approved. It's not optional. If the buyer is unable to obtain loan approval before the end of the loan approval period, you have to terminate the finance contract or waive the contingency. If you do nothing, then the finance contingency terminates and we proceed as if it was a cash offer. Except for there are a few other property related conditions and some other things that have to be met on the lender side. So the one thing that's different from the NABOR contract is in this contract, it does not say that the buyer has to document their non-denial. They just have to exercise a diligent effort. So you're going to be in a situation where it's almost an as is. If the buyer provides diligent effort to complete the loan process but isn't approved, they can almost in any circumstance terminate prior to the end of the loan approval period. So it really gives you like a long as is contract, which is one thing I do not like about this contract. Okay, Pamela is asking, how many days do you recommend for loan approval? I have a contract that has a 25-day loan approval and close date on or before November 6th, 5,000 escrow, so you have a 2-week time frame before the close date. Should loan approval be extended closer to closing date? So Pamela, and Deborah, you asked if agreed by both buyers, can't you get amendment for more time? If buyer and seller agree, then you can extend the deadline or the closing date. And I will tell you the worst, getting emails from our lenders saying they need 45 days for the approval process and then another 10 to 15 days to close. So I know sellers are hot to trot. I know the market is really hot for sellers right now, and they're not looking at 60-day closings. But if you're getting financing, you're going to be in a 45 to 60-day close. And Roshio, yeah, that's what I'm saying is, yes, the loan process today is taking around 60 days. So get yourself a longer finance contingency so you can get the approval through, especially in this contract where when at the end of the loan approval period, then the buyer's deposit goes hard. Okay. If the buyer does not waive or terminate, then the loan is deemed approved, but the seller has 3 days to terminate. Why is that? If the seller terminates, the buyer gets their deposit back, but then the seller's not locked into a long-term closing where they know the closing isn't going to happen because the lender hasn't approved the financing. Allie, you're saying you're new to the area but experienced agent. Do many people use the NABOR contract? I would say in Collier County, the majority of the agents use NABOR. In the rest of the state, the majority of the realtors use the FARBAR as is. So depending on where you practice, the majority of the time, although the FARBAR as is perfectly valid in Collier County, just like the NABOR contract. Okay. So if the loan approval is obtained, then in pretty much any case, the seller gets the deposit unless the seller defaults by failing to provide clear title or there are property-related conditions of the loan approval that have not been met, or the appraisal doesn't come in. So property-related conditions could be like FHA requirements for safe water, heating, electric, structural soundness for the life of the loan, or condo association finances. Those appear to be property-related conditions. Now, the contract also gives an opportunity to check the box on line 125 for assumptions, but they're not really done any longer because everybody wants a lower interest rate. And then if you're going to do seller financing, please, please, please use your seller financing addendum. It is, and I will find it really fast for you. It is addendum number C, letter C on the comprehensive rider to the FAR contract. It's the third one in. So make sure that you are using that form appropriately, fill it out completely. There's a lot of choices in seller financing. I do a lot of this, so if you have questions on that, just contact me offline and we'll go through with it. Okay, Pamela, so should loan approval date be extended up and through the closing date timeframe to protect the buyer's escrow? Pamela, if your seller will agree to that, absolutely. You want as long an approval period as possible to make sure the financing is all wrapped up prior to closing. But again, your lenders are giving you 45 days, and they're issuing these loan approvals, and then it's another 10 to 15 days to close. All right, so the financing contingency, it's pretty simple. Looks a lot like this. We're going to go through a chart now so you get a better understanding of it. So the loan approval period, the buyer must be diligent. They have 30 days default, but obviously you want more than that for their loan approval date. The buyer then notifies the seller that they're declined, and the contract ends and the buyer receives their deposit back. Or if they're not declined or they don't approve, the seller has 3 days to cancel. If they do, contract ends, the buyer gets their deposit back. If they don't, or if the buyer notifies the seller that they have loan approval, the contract proceeds and the buyer's deposit is non-refundable. But there are still property-related conditions. Yes, if they're out there, then the contract can end and the buyer can get their deposit back. If there aren't, go to closing. Yay! So make sure that you understand the finance contingency very well. One last point, the Latent case, I mentioned there's a terrible case out there a couple times. This case, basically the buyer lost their deposit because she didn't apply for the loan stated in the contract, and the court strained itself to give the deposit to the seller. If you change loan products, you must amend the contract to protect the deposit. That's what this case said. So be very, very careful. If you change loan products, if you're going to $500,000 loan for $500,000 purchase on a $400,000 loan, you're going for 80% conventional financing, and you switch to FHA because you can get a better rate, or you switch to a 15-year fixed because you can get a better rate, you have to amend the FAR contract, or you fall into the Latent case and you don't get your deposit back if the loan falls through. So I want to make sure everybody understands that. Are any questions on this? You must amend the contract to conform to the loan product that the buyer is getting. Jim is saying, is that just on the FAR? Yes, Jim, it's just on the FAR. On the NABOR contract, it's much more flexible. And I'll say frankly, I sit on the committee that writes both the FAR and the NABOR contracts. The NABOR financing contingency, as annoying as it is so much better than the FAR financing contingency. So depending on what you're doing, who you've got and what your process is, you need to pick your forms. Ali is asking, is it an out? No, it's not an out, but it's a problem for the buyer. It's not an out for the seller if they change loan products, unless they can find a way to declare a default, which is possible. Zolma, do you have to know if you change lenders? No, it's the amounts and the dates that matter, the time frames that matter, not the name of the lender. Okay. Any more questions on financing? Okay, Kim is asking, did you ever, what are you saying here? Please review the best way to notify seller of buyer's approval. It's not a certain form. It could be an email. Just forward the loan approval document that you received from the lender, Kim. It's very easy. If you had your buyer, Renee, qualify for 2 products and haven't decided, well, they better pick one. Under this contract, they better pick one prior to entering into it. And yes, Ali, you would send over the conditions as well. Okay. Closing costs. Oh, whoops. Pamela, yes, the financing contingency applies. That's a good question. To the as is and the regular contract. It's the same financing contingency in the as is and the regular contract. Matter of fact, I believe the font was an as is contract. Okay. Closing costs, fees, and charges. All right. So here's where we get into my favorite part of who pays for title insurance, right? It's always a question. So closing costs for the seller, they pay up to, depending on what you negotiate, there are blanks on line 136, 138, and 140 for this. You pay up to 1.5% for general repairs, 1.5% for WDO, and 1.5% for open permits, for a total possible default amount owed by the seller of 4.5% of the purchase price. That can be a big number. So you got to be careful when you've got your listings out there and this contract is presented to you, the FAR bar regular, make sure that you know the maximum out of pockets for the seller and you put it in there. And then of course there's escrow up to 125% of the cost of repairs for the as-is maintenance requirement or to complete all the other repairs. So note that as a difference also from NABOR, it's 125%. And that the seller must maintain the property as is as of the effective date. Of course, the buyer pays for loan costs, association costs, and other costs. Okay. Title evidence and title insurance. At least 15 days or 5 days for cash prior to closing. The title commitment is obtained, bought, and delivered to the buyer. The seller gets it and delivers it to the buyer. The seller has to clear title and make sure that it's clear. We'll talk about that a little bit later. But the municipal lien search searches for unrecorded municipal liens. That's for 159 bonds and 170 assessments. That's paid for by the seller. And then you have to figure out who picks and who pays for title insurance. I want to point out that this contract, this is by custom. There are no legal requirements. Obviously, you want the best deal for your customer. So don't feel obligated because you're in Collier County to pick that the buyer pays for title or seller pays for title in Lee County. The note though that the buyer always pays for the buyer's lender's policy. Okay, I'm being asked to mute here. Who is talking? Someone is talking in the background. You got to stop. I'm not sure who it is or where it's coming from. There we go. Okay. All right. Sorry about that. And Pamela, you're asking, are many people still use? I still see the standard contract sometimes. Yes. So yes. All right. Special assessments. The seller pays the full amount of liens imposed by a public body. So it's the full amount of the liens that are on the property. The does not include condo and HOA special assessments. Those are dealt with on addendums A and B of the comprehensive rider. Those are dealt with differently than we're talking about municipal liens, public body liens. The lien must be certified, confirmed, and ratified prior to closing, and the buyer pays all other assessments. And then, of course, when you have installment payments, then you can pick who pays what and when, obviously based on who you've got. And this provision does not apply to CDDs. They are on a separate standard. Okay. So the next choices you have to make are about the survey. So on or before the title evidence deadline, the buyer may, at buyer's expense, have the property surveyed and furnish that to the seller for objections. We'll talk more in detail when we get to the survey section and the standards. And then, of course, there's no default for the home warranty. Well, either the buyer or the seller could pay for home warranty plan, and that would be provided for at closing. Okay, more about special assessments and municipal special assessments. The seller responsible to pay the full amount. All right, you know what? Did I go backwards? I already said this. Okay. All right, let's get into the disclosures. So these disclosures. Oh, whoops. Jim has a question before we move on. Can I ask a neighbor question? If so, can seller have buyer pay transfer tax without messing up the standard language in the agreement? Jim, that would mess up the standard language in the agreement, and you would have to modify it and talk to your favorite closing attorney to get that done. Okay, permit disclosures. The seller is warranting that there are no open permits or unpermitted improvements. What does that mean? That means that if the seller knows that there are unpermitted improvements or that there were open permits, they are immediately in breach of contract, and they are running afoul of possible warranty claims, which means that it may be worse than just being sued in a contract case. It may be a tort case for breach of warranty. So be very careful when you are talking to your sellers about that. Rosemary, you're asking if the seller has a survey, they're required to give it to the buyer. Yes, they are. They don't get paid for it. Okay. So again, permits, unpermitted improvements. If you've got the seller and the seller tells you, oh, by the way, this kitchen was remodeled and I didn't get a permit, you now, as the realtor, have knowledge of an unpermitted improvement. You have an obligation to tell the buyer or the buyer's agent of the unpermitted improvement or the open permit. You can't hide it for the seller. It's a Johnson v. Davis issue. Don't do that. Okay, lead-based paint. Here we go. Whoops. So don't forget your disclosure. If your home was built prior to 1978, don't forget your lead-based paint disclosure. It's in the contract, but you have another form that has to be filled out. Okay. Ferpta is a foreign interest in real property tax act of 1980. So the seller has to fill out a non-foreign certification or have some other exemption. I teach a whole class on Ferpta, so we aren't going to spend a lot of time on this. Or the buyer has to withhold 15% of the purchase price and remit it to the IRS. Okay, so other disclosures. The seller is making a representation pursuant to Johnson v. Davis that there are no known latent defects which materially affect the value of the property. So that is no known uncorrected building, environmental, or safety code violations. That's no hiding mold by painting over it. That's no hiding leaks in the roof by painting over the water stain on the ceiling. You must disclose known latent defects that materially affect the value of the property. If it's going to change the value of the property and you're trying to hide it, then the seller has liability and you as the realtor have liability. So be very careful. Pamela, if you're asking, does the seller have to disclose that the home was remediated for defective drywall? If the drywall was fully and completely remediated, that means they changed the pipes, got rid of all the corrosion and took care of it, then the answer is no. Otherwise, I would say yes. Okay, further on seller's disclosure, COVID, do you have to disclose COVID? Probably not. There are many statutes in Florida that talk about not having to disclose AIDS or deaths. The Fair Housing Act prohibits inquiries into whether an occupant has a disability, including questions about medical conditions. So you probably do not have to disclose COVID in the house. Jim is asking, is Chinese drywall a latent defect? So Jim, the answer to that question is, it depends. Latent defects are defects that are not readily discoverable. So if the buyer does a Chinese drywall inspection and doesn't find any, but you know that it exists, then you've got a problem. So it's kind of a question of what did the seller know and when did they know it? I always err on the side of disclosure. Put it in your seller's disclosure that there used to be Chinese drywall and that it was completely remediated. That way you don't have a question about it later. That's the safest way to do it for you as the realtor, and it protects your seller. Okay. Property maintenance, conditions, inspections, and examinations. All righty, so this is a big section. Obviously the contract takes up a couple of pages, so we'll go through it in detail here. Property maintenance is very important. The seller must maintain the property as of the effective date, wear and tear accepted. That includes property, the lawn, shrubbery, and the pool. When you're doing your inspections, generally you have 15 days to do the inspections. The buyer gets 3 inspections under this contract. That's the general inspection, the WDO, and the permit. Note that the buyer does not get the mold and radon inspection under this contract. So if your buyer wants mold and radon, we need to do an addendum. And the seller is only obligated up to those repair limits that we discussed earlier for each of these 3 items. Pamela, I do not know of a way to search if a home was remediated unless you check the permits. Okay, so general repair inspections must be done by licensed professionals. The buyer can ask for general repair items only as defined in the contract. So the property is to be free from leaks, water damage, and structural damage. The items listed should be in working condition, which is designed as they were intended to. And of course, cosmetic items do not have to be fixed by the seller. And then when the seller receives the inspection notice, they have 10 days to make their own findings, do a re-inspection, bring in a third party whose work is definitive, and then if the proper notices are not given, either party may terminate. Okay. John, you're asking, so if the AC is out and there is no WDO or open permits, the 1.5% is all the buyer's entitled to. John, that's correct. Under this contract, if you just did the defaults, then the general inspection would be 1.5% of the contract price. And so depending on your purchase price is how much the buyer gets to get that AC repaired. Okay, WDO. The buyer may have the property inspected for WDO. That's any arthropod, plant life that damaged seasoned wood. Fences don't count. And the seller does not have to retreat if there's been treatment and no live infestation is found, but the seller must transfer the warranty. So if the seller's got a WDO contract that's got a warranty, then they transfer that warranty. And then, of course, they have 10 days to have any treatment estimated and must pay up to the repair limit to have those repairs made. And then either party, again, may terminate if the proper notices aren't given. Permit inspections. So you can check the property records, look for open and expired permits, tell the seller, and then the seller has 10 days to determine the cost to close out the permits, and they've got to get them closed out 5 days prior to closing. So that can be a very difficult process right now. The county is taking 3 to 4 weeks. That's 15 to 30 days to get back to you on whether you've got open permits on the property. So plan for that. If you know of them, then or you think there's going to be a problem, then you're going to need a longer inspection period. So make sure you account for that. And then of course, the buyer gets a walkthrough reinspection 1 day prior to closing. And they get to confirm that all items are out of the property, that the property has been maintained, that the repair work has been done, and that the seller is left the property broom clean and free of debris. Jim, we order permit inspections. So we take care of that pretty much as a standard procedure. Pamela, if an item breaks prior to closing on a contract, is the seller obligated to repair? Yes, in all the contracts, the regular and the as is, the seller has a maintenance obligation. They got to maintain the property as is, as of the effective date, wear and tear accepted. So in your example, if the AC breaks, the seller has to repair it. Now, I'll talk real briefly about the as is. It's a free look. The as is contract has all the same terms. Has all the same terms for everything else except inspections, and it's basically a 15-day free look for the buyer. They have all the time they need to during the inspection period to conduct inspections and make a decision. Allie, you're asking, many times I presented FAR bar, but the agents want to present it on an as is and won't accept. Are there any obligations to present the other? So Allie, depending on whether the seller has told the listing agent in writing that they will only accept as is contracts, then the listing agent would be obligated to present the regular contract. Okay. So let's talk about the escrow agent and the broker. So we receive the funds as the escrow agent subject to collection, and wires are immediately available, whereas checks take 7 to 10 days. So just because the seller tries to deliver a check for closing, that's a failure of performance by the, I'm sorry, I said seller. Suppose the buyer tries to deliver a check for closing, that's a failure of performance by the buyer, and it's going to be subject to breach. So basically, always use wires. Don't use checks for closings in real estate anymore because they take too long to clear the banking system. So this contract has another provision that's helpful to you as the realtor. It says that it relieves you of some liability for providing your advice. However, it does not relieve you from your Johnson v. Davis obligations to disclose known latent defects. Please be careful of that. You, as the realtor, are liable for the seller's malfeasance. So be cautious there when you're taking your listings about making sure you keep your sellers honest. Okay, default and dispute resolutions. The seller may take the deposits as liquidated damages. The seller may go through mediation and then sue for damages or attempt to force the buyer to close. And then, of course, any deposits recovered are split between the seller and the listing agent up to the full commission. And the listing agent has to pay the split to the cooperating agent. So be mindful of that. The buyer and the seller have agreed to mediate their disputes before suing each other, and the winner in any lawsuit gets their attorney's fees paid by the loser. So that's a hammer that you can use. Okay, so let's talk about the standards in the transaction. We're going to go through these fairly quickly because they are not supposed to change. So the title standards, the buyer has 5 days after receiving the title commitment to notify the seller of any defects. This is an opportunity to extend. The seller could get up to 30 days to fix the title defects. If they can't extend, the buyer can extend the contract for another 120 days or take title as is or terminate. So this is an opportunity for the buyer to extend the contract and keep the seller in the deal. The seller does have to expend money and clear violations. If the seller can't, then they get their money back. The buyer gets their money back. So the buyer has 5 days to deliver survey objections from the day the buyer receives the survey. And the survey objections are treated as title objections. So see the previous slide. But I got to tell you, the survey is so important. in terms of making sure there's access, making sure that there are not setback violations or encroachments. It's very important to get the survey as quickly as possible. And we order the survey for you. And then, of course, for the seller has to deliver the tenant estoppels. And if the estoppels don't match the leases that were delivered at the beginning of the process, then the buyer can terminate. Okay, I get questions all the time about time in the contract. Calendar days are used for time periods. Time is of the essence for all deadlines. Does everybody know what it means when I say time is of the essence? I can see your faces, shake your head. Time is of the essence. This is such an important term. If you miss a deadline, any deadline, don't get your deposit in on time, don't get your inspections completed on time, you lose the rights. And if you miss like a second deposit, you're in breach, the contract can terminate, and the seller can keep the first deposit. So be very careful about that. Now, the contract is unclear about times after weekends and holidays, but it's 5 p.m. on the first business day afterwards. Jim is asking, do you get buyer permission to order a survey even during the inspection? Yes, Jim, we order a survey right away because there's always survey problems these days. So we order a survey, we tell our buyers, get a survey, we talk to them, and we get a survey. Pamela, you should always review the contract with your buyer. It is going to open a lot of questions. That's why you need to come to these seminars, and that's why you need to have a good relationship with your closing agent and your attorney to make sure that those questions can be timely and appropriately answered. You should not be giving legal advice. Call me, call my cell phone, email me, call me nights, weekends, Christmas morning. I will answer the phone and I will get you the answers to your contract questions. It's very important that you not guess, or that you have a buyer who doesn't know what they're doing going into contract. Okay, force majeure for COVID. So this is the force majeure clause in your contract. It's 3 sentences. I'm not going to read it to you because you can all see it in your contract. If you look on, where is it? Line 513 on page 10. So performance is not required during a force majeure event. Force majeure is defined in the contract as hurricane, flood, extreme weather, act of God, etc. And time is told for a limited period. So the deadlines, including the closing, are extended until 7 days after performance is no longer prevented by the force majeure event, and you cannot go past 30 days or either party may terminate. So what does this mean in the era of COVID and the pandemic? Well, is COVID or the pandemic an excuse to a party's performance? So I put some examples here on the screen. Buyers' cash deals, they sign electronically. There's no notary, no witnesses. Buyers must sign their closing docs and perform. Wire your money in, DocuSign your documents, enjoy your new property. If the buyer is getting a mortgage and the lender allows the remote online notary, then they're going to, buyer, you're going to perform, you're going to sign remotely. It's going to cost you a few bucks and you're going to go to closing. Sellers, you can sign with Ron, remote online notary. You're almost always going to be required to perform because you just have to receive the wire. All right, Pamela, you're asking me. Pamela, the survey is, we order the survey, not the lender. And there is protections in the contract that I went over. It's treated as a title defect. Okay. So back to these scenarios. If the buyer can't get a certificate of approval from the association, probably can excuse performance. If the buyer gets the certificate of approval, but the association won't let them move in, buyer still has to close. If the seller can't move out because the association won't let the movers help, that's probably a COVID event that would be on the seller side. So I will tell you right now, there's some cases out there, but they are generally not favorable. Florida likes contracts. We like keeping people in contracts. We like contracts being performed. We like promises being kept. And COVID, as weird as it's been for us for the last, what month are we in? October? For the last 7 or 8 months, it's probably not going to get you out of your contract in Florida. Okay, prorations. They are to the day prior to closing. So there's some question people like to ask me, why is the proration off by a day? That's because the contract says so. Advanced rents and security deposits are credited to the buyer. And then you use last year's millage on the tax bill unless this year's taxes are out. And new construction gets pretty complicated, but we can figure it out. It's 80%. Okay, a few other issues. You've got your risk of loss. The seller is responsible up to 1.5% of the purchase price only. So if the house burns down and there's no insurance, then the seller does not going to have to pay to rebuild the house. Okay, if you have a seller or buyer who is participating in a 1031 like-kind exchange, please note that the language required to facilitate the 1031 exchange is already in all the standard contracts. So you don't have to put it in there in the additional terms. All right, integration and modification. This is actually a very important issue. All of the representations in the MLS, all of those emails that went back and forth between all the parties talking about the property, those are all wrapped up in the contract. So anything that happened prior to the contract signing is not actionable, unless, of course, there's fraud. So the language of the contract is, this contract contains the full and complete understanding and agreement of buyer and seller with respect to the transaction contemplated by this contract. Here's the important part. And no prior agreements or representations shall be binding upon buyer or seller unless included in this contract. Make sure that you understand that all those emails and MLS representations are not in the contract unless you expressly put them in here. Tina, what line is the 1031 exchange? That is, it's standard N on line 590 on page 11. Okay, with that, do we have any questions? Go ahead, you can unmute yourself, or let me if I can figure out how to unmute people. Raise your hand in the chat, or unmute, if you can unmute yourself, or wave and I'll try to unmute you. Any questions?
It's Allie.
Hi, Allie, go ahead.
Regarding the FAR bar, and if the seller has stated only as is, how would the buyer's agent know if that was presented in writing to the agent?
You have to take it on faith that your listing agent is not violating the law.
Okay.
If you believe that they were, if you had other information, you could call them on it, talk to your broker, have your broker call their broker. And if you had a real evidence of a violation, that's a FREC violation. You can turn them in. Other questions on the FAR bar contract, as is any of the addendums?
I have a question. Did you say that if a buyer defaults and their deposit is in jeopardy, does just the listing agent get part of that deposit?
No, if you look at that here on if you go to lines 419 and 420 on page 8, you'll see that the listing agent splits the commission collected with the cooperating broker up to the commission amount.
So what part goes to the owner and what part goes to the two agents?
50% goes to the seller, 50% goes to the agents to split 25% each.
Great. Thank you so much for that answer.
Janice, if you scroll up in the chat, you're asking about how to get a copy of today's outline. I put the slides in the chat. It's the very first thing in the chat. So you can scroll up. Rosemary, if buyer sent money to close to title company then wants to cancel, what forms are necessary? Rosemary, you would need a termination probably drafted by the buyer's attorney that says what the reason for the termination is and why they're entitled to the deposit back, and then the seller would have to sign off on that. Other questions for folks? Pamela, a lot of times sellers prefer the as is. This is stated in the MLS under confidential comments. If it's in the MLS, they prefer the as is, use the as is. Everything I've said here today, with the exception of the inspection provisions, applies to the as is contract. So I want to be clear about that. The financing, the standards, it's all the same except for the inspection. So if somebody wants an as is, use an as is. If you know it's going to get rejected out of hand regardless. Now, the other thing I've got here is I've got the comprehensive rider. Does anybody have questions about any of the addenda? There's a lot of them. It goes from A to, I think it's double C now. Double B, binding arbitration. So any questions on anything else? Terry, yes, I'll post the video to YouTube. All right. It's right at 11 o'clock, 11:01. Oh, wait. If the seller receives a cancellation and does not want to sign, what should I do as the seller's agent? Well, you need to communicate that the seller is not going to sign to the buyer. And if there's rights, the buyer may have to engage an attorney, Rosemary. Deborah, the docs are at the very top of the chat, Deborah. Scroll up to the very top of the chat and you can get a copy of the slides. If anybody wants the slides, email me. I will tell you, you can call or email me anytime and I'm happy to answer your questions. You can call me on my cell phone. No problem at all. What is this, Jim? What are you asking me here? If the MLS listing states seller to pick title, buyer to pay doc stamps, does the listing agent still need to present offer when buyer picks title? That depends on the written instructions to the listing agent from the seller. If the seller doesn't instruct the listing agent to reject those out of hand, then the listing agent must present. Tina, does listing agent have authority to take standard contract rewrite in an as is? Yes, if the buyer makes an offer on the regular and the seller wants as is, the seller can absolutely counter on the as is. Kim, I don't know what my YouTube channel is. I think if you search for Sam Saad, the third Naples attorney, I'll pop right up though. I'm not in charge of that. All right, everybody, I don't want to keep you. You can contact me offline. Thank you very much for your participation today. And the slides and the YouTube will all be posted soon. Thank you.